Are you ready to finally make that dream a reality? Maybe it's updating your kitchen, paying down high-interest credit cards, or covering tuition. Your home is more than where you live. It's also your most powerful asset. At Unlock, we make it simple to turn equity into options. With a home equity agreement, you can access cash today without taking on monthly payments. Imagine the freedom to invest in your home, reduce financial stress, or finally start that big project you've been putting off. It's your home. It's your future. Unlock it today. Visit unlock.com to learn more about a home equity agreement. That's unlock.com to learn more.
Terms and conditions apply. Not all homeowners will qualify. Not available in all states. Actor Portrayal. Home equity agreements are offered by Unlock Home Equity Solutions, Inc. In certain states, NMLS number 2657081. Visit www.consumeraccess.org for more info.
Welcome back to Come Back with a Warrant podcast. I'm Brandon Dinitz.
And I'm Monica Ashak. Before we kickstart this week's episode, this is your reminder that this podcast is not legal advice. It's real, unfiltered, and for entertainment purposes only. If you need to speak with a lawyer, call one. Or better yet, call us.
So we're back here with another episode, and today we're talking about standing your ground and self-defense, because the misconception here in Florida is that everybody can just shoot anybody that comes onto their property, and that's not exactly how this works. So we are going to break down the stand your ground law in Florida and self-defense in general, because, you know, there's certain things that can get you into trouble, but self-defense is one of those things where oftentimes people are arrested first and then get to prove self-defense later.
Yeah.
So a lot of it comes down to being justified, and yeah.
It's literally breaking down what happened second by second. Like, you need to break it down, because you can come into the office and say, like, yeah, I was defending myself, and like, that's our defense. And I'm not saying I raise it a lot. Like, I enjoy those are the fun cases for me. Like, self-defense cases, filing stand your ground motion, having a hearing on it, like, those are fun. But obviously it's real facts. So we need to break down what it is that allows people to raise that defense.
Right.
So the first things first, and this is something that people don't know, is that Florida has removed any obligation to retreat when you're in a scenario, meaning if you can get out and if there's an opportunity to get out, you don't have to. You can fight back in that moment. And so certain states, I should say, probably do have a duty to retreat. You have to basically use self-defense as a last resort, but that's not the case here. So that's, I think, the first thing to say. But also the other thing is that we don't call it self-defense under the law. We call it justifiable use of force. And then based off the force used, is it deadly or non-deadly force? So it's the same law. It's just, was it necessary to use the deadly force? And so we'll talk about that. But all that to say is that I think stand your ground and I'm saying stand your ground, but is that the name formally of the law? No, right? That's just like what we call it.
Everybody calls it Florida's stand your ground law.
Yeah.
So that is how it's most known, I think, to probably our listeners, and how even we as lawyers refer to it amongst each other more as stand your ground
motion,
so,
whatever.
Right.
Yeah.
So that's what we'll stick to calling it. I mean, and that is what it is you do not have the duty to retreat or run away, so you can stand your ground. But the question becomes, okay, so does that mean if somebody punches me in the face, can I just shoot them in the face? Well, it depends on the situation. And like most things with lawyers, everything depends.
Yes. Yes. There's that running joke. Whenever you ask an attorney a question, the answer is it depends. Yeah. So we'll never have a straight answer for you.
Right. That's true. There's no straight answers.
Hence why we have this podcast. So make sure you stay tuned. But what counts as justifiable use of force? So what gives rise to self-defense? Obviously, somebody would have had to initiated or been the aggressor. So that's like the first thing, identifying the aggressor. If you're in a scenario where it's somebody, what'd you say, punch, slap?
I said punch.
Yeah. So someone punches you in the face, an appropriate self-defense case would probably be like a slap, another punch, something that
shove something back, right,
meets that level of force.
Right.
But it has to prevent like you're in the like, and that's why I said it's like a second by second. You're breaking down the time frame of what's happening, because if there is a break in time and this person smacked you, walked away, and you come back 5 minutes later, you smack them, that's not self-defense.
Right.
So that's another crime.
Right.
Like at that point, it's just mutual combat, I guess. But
yeah, and in a worse scenarios where somebody walks away, grabs a weapon, comes back, and then uses the weapon, that's not self-defense.
Yeah.
But having that weapon on you, well, what does that do? And what we see, there was a case recently in Florida within the last few years where 2 men were outside of a convenience store. One pushed or punched the other, and that person fell. And when they fell, and while they were on the ground, they pulled out a gun and shot and killed the person that had hit them. And that immediately became a stand your ground situation and a stand your ground case. And you have to look at, exactly like you're saying, each second. Is the force proportionate? Was it necessary to do that? Was there any other way to defend himself besides doing that? Was the guy still coming at him after he had fallen to the ground?
Yeah.
There's all these different things that come up and come into play.
And the words you say too.
Correct.
Things you say. Like if he said like, I'm going to shoot you, or I have a gun, or I'm coming for you, and he, after being shoved down to the ground, perceived that as like a real threat, then you can use force to prevent imminent harm in that moment. So even though it was a push, so like those are things that all like the witnesses come, in front of the judge, and like the jury testify to speak on these things, and then the fact finder, whoever it is, would then decide, is this self-defense or not? And oftentimes these are not easy decisions.
No, and they're all case by case, and they're all fact driven. They are so heavy in the facts because we're all understanding what the law itself is on self-defense, but now we have to apply a very specific set of facts and down to the second of each incident that occurred.
Yeah. And the other thing is, so this ties into what I was saying as well, is like if there's a reasonable belief that there will be something carried out by that person, and it's that reasonable belief is defined by the law. So it's not something that like we use all these words, like what do these words mean? It's what an ordinary person in that moment who is in that situation would believe, not what you personally think it should be. So like those are all things that need to be, it's kind of a subjective kind of.
It is a subjective standard because we're looking at the specific individual in that
moment.
Right.
Yes. And it's not like, oh, if it were me, I would do X, Y, and Z.
Right.
So that's what also comes into play. And I think that there's just so many different things that like come into play with it, and you just have to break it down. And so this is something that I learned just through practice, but there was a point when I was at the public defender's office and COVID hit. And so like they suspended jury trials. I didn't have any way I was in domestic violence division. I didn't have any way really to get these cases closed out. And I had requested to be in that division because I wanted more trial experience. And I was excited for the trials. I was excited for whatever was to come. And obviously I didn't get that opportunity because they suspended everything. And so I had clients like waiting in custody and I would say that division had more people in custody because just considering factually, if they're released back, they would be going back into that home where they are sharing a space with the alleged victim because it's a domestic violence case. So that division had more people in custody than other divisions. And so I had a lot of clients who were in custody, even though I had filed bond motions and all the things, they were still in custody. And so there was the only way to get them out was to file if they had a viable stand your ground motion or a self-defense case. And so I raised them, and I would probably say like 25 to 30% of my caseload. My caseload was going up because we weren't really closing much out. And I reached like over 300, I think almost 400. And that was out of the ordinary for us. Like we were on a regular that was like 130, 140, 150. It was not, it doubled. So I just filed stand your ground motions. And I was like, you know what? This is like a risk-free way to really see if this is something that we can get done. And I was like successful in a lot of them. I think the court, because the judge is the one who decides, not the jury. And that's why I was able to do that. And it's kind of like a mini trial or mini hearing where the state presents their witnesses. Usually it's the alleged victim. Obviously it was misdemeanor, so they weren't dead or anything. They would come to court and testify, or sometimes they wouldn't come, and then the state would be obligated to dismiss it because they don't have their witnesses ready. But it's definitely something that I learned that I had to explain to the judge why it was self-defense. I had to tell the story from my client's eyes, what happened. And sometimes I had to do that without my clients testifying, because sometimes I was concerned about them testifying. And so it's really like, that's why I say I like really do enjoy it. Like I enjoy doing that, but it's obviously like trial work, litigating in general, but it's more nuanced and like step by step, like, okay, what happened next? Like they reached for the gun. What did you do? What did they say? Who was around? Who saw that? Like we're breaking down everything for the court or the jury to feel like this is a real time thing that they are a part of and can really like envision and see what's going on, because not just because of, that's the art of storytelling and all the things, but it's also so important to meet the legal elements of self-defense.
Well, this is one of the only times where we're directing the court or the finder of fact in the situation to put themselves in the position of the specific person, as opposed to what objectively a reasonable person would do. We need to know what that person would do in their situation that's reasonable. So it's different, and it requires the lawyer to do a lot of very, very specific, I would say storytelling, because you need to put the judge in that person's shoes enough that they would say, oh, well, yeah, then there was no other option other than to act with the self-defense that this person acted with. And obviously, when we're dealing with the misdemeanors, the self-defense that you're talking about is nothing more than a pushback, a punchback, something that's no weapons involved. We're not talking about certainly no great bodily harm or death, but the is completely different than what we normally are doing. Different also because as the defense, we're the ones bringing this, as opposed to normally when the state is the one bringing everything in the case. This is us putting on a defense, and we're not required to do anything.
Exactly.
But we do this and make the decision to do that, and it's a challenge. And you're also, on the downside, if you are raising self-defense, this type of claim, and you are unsuccessful at the stand your ground hearing, then you now have the obligation to put on a self-defense pretty much at trial. You're stuck to everything that came out in that self-defense hearing. So, and your client's going to wind up testifying again because you need them in order to prove that self-defense. So a bad stand your ground hearing could have bad consequences, because you'll be in court for the regular trial and you're tied to all of the bad things that came out during that stand your ground hearing. So if you're on the fence with stand your ground or with a self-defense claim and you don't know whether or not to bring it, sometimes the way to deal with it is to wait to bring that self-defense claim at the trial. And, that's just one strategically something that happens.
Yeah, it's a strategy decision for sure. I've had them without my clients testifying, and they've been successful sometimes, but also depends, like, was there a third party there to testify on their behalf? Was my cross good enough to the point where I was able to get the facts I needed out? Or, whatever the case was. But you cannot raise, you remind me while you were talking, you can't raise self-defense if you, because this happens to me a lot, where I have conversations with people and I'm like, well, like, what happened? Like, tell me what happened. People being my clients, they don't want to admit that they touched the other person. And it's like, you can't say you defended yourself. You can't raise self-defense legally without admitting that you touched this person.
Right.
So you have to say, like this isn't technically like, this is what we call an affirmative defense. Like, yes, but like, yes, I did this, but it was legal because X, Y, and Z. And so this is something you can't just say like, oh, like, I didn't touch them, but they came for me. They came at me first. Like, it's either you didn't touch them or you did.
And now the prosecutor gets to say, when this case goes to trial, if you lose the stand your ground, the prosecutor can get up and say, and ladies and gentlemen, the defendant admits to doing this. You're not going to hear any dispute about them actually doing it, actually hitting the other person. They're going to get up and take the stand and tell you themselves that they did it. Like, you're going to get to have that card in your back pocket and not have to worry about proving part of the elements that the state has to prove is now met, because you're boxed in with the self-defense claim, as just like you said, with an admission.
Yeah. But they do have to disprove that it's self-defense beyond a reasonable doubt.
The state.
Yeah.
Correct.
So
once it's raised.
Yeah.
Right.
which is beneficial because it's like beyond a reasonable doubt is such a high legal standard. And it's like, when the state talks about it in jury selection, they say like, it's not beyond all possible doubt. And it's like, they're trying to say like, maybe things are possible, but is it reasonable? And they're trying to get to, I don't think it's their way of trying to like lower the burden, but I think it's their way of trying to explain it to the jury. And to me, when I hear it, I'm like, well, I guess that's like, it makes sense, but it sounds like they are trying to lower the burden.
Well, they want to make it seem like it's a burden that can be met. Otherwise, it's all they're hearing, all the jury's knows is like this mountain of a burden. Like, yes, it is high. It is one of the highest burdens in the land, but it can be met. And oftentimes it is met with ease, just with the evidence. Yeah. So, But
all that to say that they have to also put evidence to show that why it was not self-defense when they're putting on their case. So that's also another kind of like good thing from self-defense laws. And honestly, I think Florida's self-defense laws generally are just more, and they've changed over the years, but they've been more like favorable for our clients. Like they're not as stringent as other states, like not having a duty to retreat. There's also the presumption if somebody enters on your property, which is considered the castle doctrine, somebody enters on your property, whether it's like your house or your car, and that you're considered to have like presumed to be in fear.
Well, and you're also, and you can protect.
Yeah, you can protect yours.
You can protect what's yours.
Exactly. So there's other states, I'm assuming, I'm assuming and I'm considering states that are more liberal, like California, New York, probably don't have self-defense laws like Florida.
I'm not sure, so I'm not going to go out and say that for sure.
Yeah.
But no, I think in California it's cool if you just go into somebody's house, take whatever you need, and just leave. Person that pulls out their gun on that person would probably get charged. Yeah, that would not happen here. And if it does, you have a viable defense. It's like the burglar who falls through the skylight and sues the homeowner insurance. Which has happened. That's a real thing.
Really?
That has happened. Yeah. No, not here. That was a case though. Like a burglar broke into a house and got hurt and sued the homeowner. Things like that happen.
The other part of that reminds me, because the other part of self-defense is that you have to have a legal right to be there to raise it.
You have to have to be where you are at the time. Correct. Yeah.
So that, because you just remind me, I'm like, when you said burglar, I'm like, he doesn't even have a right to be there.
Right. Yeah. Well.
And he got his check.
I don't think he got his check, but I know somebody that was like that
would piss me off.
That was like a suit. Like I remember hearing about that either in law school or years ago.
I need to look that up.
We'll pull that. But someone that like broke onto somebody's property sued them.
You're like, not only did you break into my house and probably
cause
damage.
Now you're driving up my home insurance rate.
Yeah. Now my premiums are up the ass.
Oh, that's funny.
And they got their check. Well, hopefully not. But anyways, so there are certain things that need to like make you eligible. And obviously that's what one of the things was like, you have to have a legal right to be there. So if you're like at an establishment and you weren't asked to leave and there was like something that happens between you and someone, then that's a place you can raise self-defense. Your house, obviously, but if you're on someone else's property and they're like, you need to get out. And I've had cases like this where my clients are like, it was self-defense and the facts match self-defense, but somebody said you need to get out and they were at someone's house. They're no longer welcome. You're no longer allowed to be there. You cannot raise self-defense. So that's also another kind of nuance, which I've had the state use as like, I guess, a defense to my stand your ground defense.
Mm-hmm.
And I was like, that was, I don't remember what happened with that, but I was like, oh, I forgot about that.
That's the counter argument.
The counter argument. Yes, exactly. So whether we're talking about deadly force or non-deadly force, the law is the same. It doesn't change. It's just that you cannot use deadly force like improportionally. Is that a word?
Proportionally.
Like, I don't think that's right.
No, you cannot use deadly force disproportionately.
Yes,
to
exactly.
what the force that you're receiving is.
Yes. And so sometimes it's on the fence, like we said, and someone's saying, I'm going to kill you and you don't have an actual gun to your face, but that could be used as, a reason to be able to use your deadly force or whatever. So when we do raise self-defense, we have to also say that using deadly force was necessary. So we have to also show that. And
given the factual circumstances, if deadly force is what is used, then that would be something else that the defense would now have to deal with and handle.
Yeah. And then obviously the defense of others and defense of property, it's the same, but it just allows you to raise the defense if you feel like, you're with your family and you were defending your family, you were in your car and someone was trying to break into your car. That same thing it doesn't have to be somebody was attacking you directly. So that's also the other nuance takeaway from that. But you were talking to me about a Netflix documentary.
Yeah. So there's a new Netflix documentary called The Perfect Neighbor, and it talks a lot about stand your ground in Florida because that is what the focal issue is of the case. And it raises some really interesting questions about stand your ground. For those of you that don't know, The Perfect Neighbor is a new documentary. It's about the killing of Ajika Owens, who was a mother of four who was shot and killed in Florida through a door. And I'll give a brief just explanation. If you want to watch it, you can see it on Netflix. But there was a woman in the neighborhood that would complain and call the police on all the local kids constantly. And the kids would be playing in, the area next to her house. And she would be calling the police over and over and over again.
Sounds like a Karen.
She is a Karen. And what's interesting is that the documentary is all filmed from body-worn. It's all body-worn camera. The whole documentary is from the body-worn camera of the officers that had been out there and interacted with all of the people involved. So the officers had gone out multiple times, and you see in the documentary they go out multiple times because she's complaining about the kids being in her area and making noise and playing and whatever. She's just, a miserable person. One night she gets into an argument with a couple of kids, and she winds up taking one of their iPads away and throws it, and she throws a roller skate at them, and she is swinging an umbrella at the kids, and she's basically going back and forth arguing with these kids. One of the mothers of these children finds out that this is going on, and rightfully so is pissed off that this woman is taking her kids' things, throwing things at her kids, whatever the case may be, their children, goes to this woman's house, knocks on the door, bangs on the door, and is trying to confront her. This woman, the Karen, the neighbor, who her name is Lawrence, is her last name, she calls the police, and without waiting for the police to get there, which she has done many, many times, takes out a gun, shoots through the door, and kills the woman that's on the other side, this mother of four. The documentary there are certain scenes that are tough to watch because they show the police informing the family, informing the father of the children, the four children that were now left motherless. And it's all there. You watch the kids find out, you watch the family find out. It's very, very difficult to watch that part. But the question that it raises is whether or not she was entitled to do that and whether or not this woman acted in self-defense. Initially, the police did not arrest her, and they didn't arrest her for quite a while went by before she was actually ever arrested. You do see in the documentary, you see the police interrogate her and the night of the incident, and they release her. You see them interrogate her other times and talk about it. Ultimately, they do charge her with manslaughter. Or I believe they charge her with manslaughter, if not with homicide, and then reduced down to manslaughter, but is inevitably charged and convicted at trial. But the questions that it raised were whether or not her actions were proportionate and reasonable. The questions it raised were about whether or not her actions would have been covered under Stand Your Ground. And ultimately, in order to charge her, these were all questions that the police and the state attorney's office in the case had to deal with and process and make a decision on. And they faced enormous pressure from the media. And because this story gained national attention, the woman that died was Black and the woman that killed her was white. And something that came up in this movie and is a question that I'm going to ask you is the racial disparity that comes out of Stand Your Ground. And in this documentary, they surmise that, and based on the data that they've collected, if you are Black, you have less of a chance of having a Stand Your Ground granted in your favor, which is something that, I've not handled as many Stand Your Grounds as you have, but did you ever see as a public defender or now that there's a racial disparity in the way that Stand Your Ground is handled, whether it's, who the victim is or who the defendant is and how it's...
No, I haven't. And I haven't like, I haven't actually had a scenario where it was like white on black, I don't think. Like crime where it was like separate races. It was because it was domestic. So oftentimes they were related to each other or like from the same community. So I don't think I saw that, but I have noticed because you're saying that, I don't know if police really investigate self-defense and I think maybe they did in this scenario because it was a murder and it was like televised in media and all the things were involved, and maybe they do that when it becomes more serious. But when I was in that domestic division, which I do have now a murder that we are going to raise stand your ground, but it's still pending, so I don't know. But back then, like when I was dealing with those, I think that there were times where my clients would tell them what happened, and technically it's considered a confession at that point. Because the way the police would write it, it'd be like they admitted to touching them, and then I would watch the body-worn camera, and they're telling them exactly what happened. And then I'm like, well, this is self-defense. But the police, like, they don't want to hear it. They hear I touch them, and then they'll arrest. So that's the only thing I really notice. And so I don't know if that's because they're like, you know what, if you have a self-defense case, you can raise it in court, and that's not our problem. Like, because they have to take somebody when it comes to domestic. But I have had domestic self-defense case. It was a felony. We had to show deadly force, but it was non-deadly, but he used a weapon. So we had to use that. We had to show that the weapon was like necessary to use.
And you have to show the fear for the life component. Because that's what's interesting about that documentary is the woman that the shooter, she immediately was telling the police she feared for her life. And they do wind up finding that she had at some point researched Stand Your Ground. So she was aware of
that was
kind
used
of the
against
language.
her?
It was brought up in the
trial,
the police interrogation that she had at some point searched for Stand Your Ground. Yeah, but I don't think it was as closely, it wasn't like she called 911, this woman's outside banging on her door, she Googled
right. It was
Stand Your Ground and then shot her. It wasn't like that.
Yeah.
It was at a prior time she had made some comment about
so crazy.
Research. Yeah. But the documentary is really good. I think it's tough. There's certain parts, like I said, are pretty tough to watch. But ultimately, if you are interested in learning more about, Stand Your Ground and a specific scenario that came up, that Perfect Neighbor documentary is pretty good.
Yeah,
to watch.
I definitely want to check it out.
Yeah.
Well, so the other thing I wanted to mention before we wrap up is that there are things that can disqualify, and I did touch on this a little bit earlier, but certain things that can disqualify you from raising self-defense, and continuing to use force after the threat is over is a crime. Right. Like, you can't do that. You can't say, I was defending myself, but then this person's unconscious and you're still beating the shit out of them.
Right.
Like, you can't do that. So obviously using disproportionate force and becoming the first aggressor. So I think that or being in a place that you are not legally allowed to be in. So those are things that could keep you from being successful in your Stand Your Ground or self-defense claims. But overall, it's like such a gift to us. I think I've seen more positives than negatives, and I've used it to my clients' benefit on numerous occasions.
I think the one big thing about self-defense cases that I tell people all the time is you absolutely could have been acting in self-defense, and there's certainly a way that we can prove that. But that was never going to stop you from getting arrested that night.
Exactly.
Because in order to raise the self-defense arguments, that's after they've been arrested. And there really isn't a time where the police are going to sit there and say, oh, this was but let's ferret this entire thing out right now. This was self-defense. We're not going to make the arrest. They will make the arrest. And if the self-defense is something your lawyers can raise, they will raise it. They'll do it effectively and hopefully get the case dismissed.
Yeah. And a side note is that mutual combat is not a defense. To just fight each other, somebody is still in Florida, they don't recognize that as. But I think that the state doesn't really pick up those cases often. But no. I did have a handful at the PDs. I'm not going to lie. It was just two people, they were both charged, and then one person ends up going to the conflict council. I'm like, not you guys charging the same people for beating each other up. Just let it go.
Well, public fighting isn't a fray.
Yeah.
So that's a crime they could charge. Very, very infrequent.
Exactly. All that to say, make sure you reach out to us if you have a self-defense case.
Yeah, for sure.
And if you like listening to this episode, make sure you check the show notes and you subscribe to our newsletter for your weekly gems in your inbox, along with our weekly podcast episode. And comment, and subscribe on all platforms. We are coming back with comebackwithawarrant.pod. And if you liked listening to this episode, give us a 5-star review. And if you didn't,
come back with a warrant.
Homes.com is the only place where you can find specialized neighborhood guides with the in-depth insider info home shoppers want. Very in-depth info. Want to know if there's homes for sale in the area? We've got it. How long has a home been on the market? We'll know it. Average lot size? Proximity to local parks? Of course. Insight into your neighbor's divorce? We're working on it. Homes.com. We've done your homework.